Hi, I'm Ashley Waskowitz. I'm going to talk to you today about contract formation and get a little bit into some of what we're learning this week in Chapter 17 regarding labor and union laws, specifically in the state of Michigan. If you just want to follow along, I'll mention what slide I'm on as I go through, and hopefully you enjoy the case that I found. So, taking a look at the agenda, first I'm going to introduce the case briefly and the key arguments on both the sides of the plaintiffs and the defendants. I'm going to then review some key concepts and terms that we've learned thus far, and then go into the critical analysis and my opinion on the case. So the case in question is brought by 3 teachers at the Taylor School District against the union, the school district, and the school board. And this is a link to find some details about the case itself. The plaintiffs are Angela Stefke, and I apologize if I am butchering their names. I shouldn't, considering I have a pretty tough name myself. Angela Stefke, Rebecca Metz, and Nancy Rodigan, and they've been teachers for several years within the Taylor School District. They reached out to the Mackinac Center Legal Foundation after being informed that their local teachers union desired to create a new contract in order to dodge the right to work law. The Mackinac Center then filed a lawsuit on behalf of these 3 teachers, contesting the legality of the new contract between the district and the union. They feel that their local union is not representing their best interests by attempting to preempt the state's right to work law and denying the members the ability to decide for themselves whether or not to financially support the union. Their goal is to have the contract voided. And just a bit about the Mackinac Center. It's actually the Mackinac Center for Public Policy, and it's a nonpartisan research and educational institute dedicated to improving the quality of life for all Michigan residents by promoting sound solutions to state and local policy questions. So looking at the key arguments on both sides, this is just, the main highlights. Certainly in the defendant's brief, they get a lot deeper into a lot of their arguments, as well as the plaintiff's brief. But overall, the main points here on the teacher side is that the agreement between the district and the union lacked consideration, which is required for a valid contract, as well as the Michigan's right to work law prohibits requiring employees to pay union dues or fees as a condition of employment. On the side of the defendants, which is, again, the school board, the district, and the union, the plaintiffs, they claim lack standing to sue. The court lacks jurisdiction, and the case should go before the Michigan Employment Relations Commission. That's one of their big respondents. It's just not something that they should be dealing with. And they feel that the court should reject the effort to attack the collective bargaining agreement by persons who are not parties to the contract. That's something we'll talk about further, whether or not these 3 teachers individually are actually parties of the contract. So now we'll talk a little bit more about the contract requirements and collective bargaining. I am on slide 6 now, I apologize, going over requirements of the valid contract. So as you'll recall, there are 4 requirements to a valid contract. First, you have the agreement, and that's an agreement to form a contract includes an offer and an acceptance. One party must offer to enter into a legal agreement, and another party must accept the terms of the offer. The second is consideration, and that's the one that is discussed in this case specifically. Any promise made by the parties must be supported by legally sufficient and bargained for consideration. The third requirement being contractual capacity. Both parties entering into the contract must have the contractual capacity to do so. The law must recognize them as possessing characteristics that qualify them as competent parties. And again, the whole issue of parties and who are the parties in this contract comes up quite a bit. And lastly, legality, and the contract's purpose must be to accomplish some goal that is legal and not against public policy. Moving on to the next slide, terms and definitions, just to go over these. A contract is an agreement that can be enforced in court. It's formed by two or more competent parties who agree to perform or to refrain from performing some act now or in the future. An agreement is a meeting of two or more minds in regard to the terms of the contract, usually broken down into two events: an offer by one party to form a contract and an acceptance of the offer by the person to whom the offer is made. Collective bargaining, this is one that comes up in Chapter 17, and the union, this states that the union is the exclusive bargaining representative of the workers. The process by which labor and management negotiate the terms and conditions of employment, including wages, benefits, working conditions, and all other matters that would be included in that. The requirements of an effective offer, that would be slide 8. The first requirement is a serious objective intention on the part of the offerer, so that's one. And second is the second requirement is definitiveness. And with that includes the identification of the parties. And in this case, the parties signing the contract are the union officials and the school district. The identification of the object or subject matter of the contract, which is stated clearly, the consideration to be paid, and the time of payment, delivery, or performance, which is also included. The last requirement of an effective offer is communication, and that is that the offer must be communicated to both sides. So looking at the right to work law, that is a statute in the U.S. that prohibits union security agreements or agreements between labor unions and their employers that govern the extent to which an established union can require employees' membership, payment of union dues or fees as a condition of employment, either before or after hiring. In Michigan, they actually just passed a right to work law. There are 24 states in the U.S. that have right to work laws. Pennsylvania is not one of them, just for the record. And Michigan is the newest state to pass a law. So they passed and drew up the law in December of 2012. They would have implemented the law immediately had they had a 2/3 majority vote in the Michigan legislature, but they did not. So with that, the effective date was moved out to March 28th of this year. The law exempts contracts that are in place before March 28th. And what the plaintiffs and the Institute on behalf of the plaintiffs have claimed is that a lot of Michigan unions began scrambling to create, renew, or extend contracts before this law was going to take effect in March. So collective bargaining. Collective bargaining is almost exactly the same in the right-to-work states as it is in non-right-to-work states. Workers and unions still bargain over those same things: wages, hours, conditions. And the only difference is that in a right-to-work state, a worker cannot be fired for refusing to financially support a union. So in the case that I'm talking about, the employer is the Taylor School District, and the collective bargaining unit is the Taylor's Teachers Union. Again, identifying that those are the two parties involved in this agreement and contract. The Michigan Public Employment Relations Act, that's something else that comes up when you go through this brief, and that says that the collective bargaining agreements cover the relationship between an employer and a mandatory collective bargaining unit. Since 1973, a term and condition of employment is that the parties are allowed to include in their collective bargaining agreement mandatory financial support for the union. It's called union security agreements, which allow school districts to fire any teacher that do not pay their dues or the other fees associated with the union. Michigan's right to work law ended unions' ability to demand that financial support. Instead, employees would now only need to